what we want to emphasize is the principle of complementarity, and that is at the core of the conception of the International Criminal Court. And it means that judicial mechanisms, investigations at domestic level, at the regional level, and additionally at the international level should all try to ensure that they don't work against each other, that there's no competition for justice, but that they all try and contribute to justice. So obviously we have the International Criminal Court. The Office of the High Commissioner for Human Rights has a commission of inquiry and a pre-existing human rights monitoring mission in Ukraine. There have been proposals for an ad hoc tribunal to deal with particularly the issue of aggression, and that has been before the Council of Europe. We know that Eurojust has established a joint investigative team, which is cooperating with several national authorities and with the International Criminal Court. The Organization for Security and Cooperation in Europe has looked into, reviewed the events and continues to do so. And of course, at the national level, we've seen concerted efforts by authorities in Ukraine. Now we see in Poland, we see Germany, Sweden, Finland, Lithuania, France, and other countries, along with NGOs, non-governmental organizations.
We are at the beginning of a long, but an extremely important, hopefully judicial process in order to deal with the potential crimes that have been committed and are being committed as we speak, potential crimes under the Rome Statute. I want to really give you an overview over victims' rights in front of the ICC, but I also want to provide you with practical advice that may be interesting and important for the many different lawyers amongst you regarding the different angles at which proceedings at the ICC can be accessed and followed. And obviously I'll be concentrating on the victim angle, and in particular also what can and what cannot be expected and done at the current stage. Now, to jump right into it, first, a little disclaimer. I'll try to be brief and give you a couple of pointers, and I hope that we'll be able to follow up on items that you find interesting and that need further discussion during the questions and answers. So wherever I'm a little too superficial, please hold me to account and ask questions. Now, let me start with telling you what actually my section does, what we do. The International Criminal Court has, if you want, as a front runner, as a first court in the international criminal law sphere, provided the possibility for victims to participate in proceedings. So in many aspects, the ICC is a pioneer in trying to make the system work. And let me tell you that there are many open questions still. But this trying to make it work is a constant struggle, because the question is always how important all actors find victim participation, in particular when you compare it with the activities of the Office of the Prosecutor or other actors in the proceedings. Now, what my section does is we are creating, quite technically, the link between victims in the field and in the world, as they may be dispersed, and the International Criminal Court. I say technically because we are the ones that really go out and try to meet victims. We are the ones that try to establish links for victims to reach us. We try to establish communication bases with legal representatives, NGOs, communities, such as this current community, in order to help understanding the ICC and the victim system, and also in order to assist and help in bringing these victims to the court in the relevant proceedings. Now, let's have a quick look at what actually we're talking about when we say victims. We have a definition for that at the ICC. We have a definition for this in the so-called rules of procedure and evidence. You have to imagine that we have the founding document, which is called the Rome Statute, and underneath we have the rules of procedure and evidence. And in Rule 85 of those rules, we have a definition of victims. In short, in order to be a victim, you have to be someone that has been subjected to harm as an effect, or as a that is a product of the relevant crimes under the Rome Statute that have been committed. So war crimes, crimes against humanity, genocide, or the crime of aggression. And you need to establish as a victim that the harm is indeed connected to the commission of these crimes. The harm needs to be personal and not necessarily direct. That means not only victims that immediately and directly suffered harm can be participating as victims, but also those that are, for instance, indirect victims. Think of those that have lost their loved ones in certain alleged crimes. Think of all those that suffer from the direct victimization of others with whom they stand in a specific relation. Now, this is where my section comes in. We try to gauge from victims that information. So we're the ones that collect this information from victims and try to then bring such information to the relevant chambers at the court in order then for the chamber to decide on an individualized basis for each and every victim individually as to their possibility to participate in proceedings. And we will get to what these proceedings are. Now, let me quickly tell you something about what those rights are in proceedings. Again, I'm making reference to the rules of procedure and evidence. You can, in particular for the lawyers amongst you, have a look at Rule 91 of the rules of procedure and evidence, where you will find that victims that are allowed to participate in judicial proceedings have quite a large array of procedural rights. They're called participants, which means that they are not bequeathed with the same rights as, for instance, the defense or the prosecution. However, there is a long list. It is not just access to the case file, in particular also much of the confidential, non-public case file. It is also the right to file motions, to respond and react to legal motions of the parties, the defense and the office of the prosecutor. It is the right to also question witnesses of one of the parties with the leave of the chamber, or even to provide own evidence. So you see the list is actually quite long. And how does this work? Now, this works through counsel, which means, in other words, victims have a right to participate in judicial proceedings, but it has to be through a counsel that appears on their behalf in the courtroom. This is understandable if you look at the mass criminality that the ICC deals with and the thousands of victims that would be affected by a single case. And we've had this, and we have this, that we have for one single case, many thousands of victims that fall within the remit of the charges. Now, for these counsel, that will be interesting for some of you to know. There are certain minimum requirements. If you were to want to appear as victim counsel in ICC proceedings. So first of all, we have an office here, an office from the ICC that provides services to victims in the courtroom. It's called the Office of Public Counsel for Victims. But at the same time, we have the vehicle of external legal representation of victims. That means, in other words, external lawyers can appear in court on behalf of victims, victim groups, and represent their views and concerns to the judges at relevant junctures. Now, what do you have to bring along for that? You have to be an experienced lawyer in your relevant own jurisdiction. You have to have a minimum amount of years of relevant practical experience. You have to be proficient in one of the official languages, of the working languages of the court. And there is a number of other requirements that you would have to fulfill. If and to the extent that this is interesting for some of you, I think this would be something that we could give you further and more concrete information on. There's a section that deals with this, the counsel support section. So for those of you that are interested in being on that list of counsel, so to have the general right to appear as victim counsel before the ICC, that would be maybe an appropriate separate juncture where we could provide you that information. Now let me get back quickly to the definition of victims and their position in relevant proceedings. Now, victims, when they participate, it is written in the Rome Statute in Article 68, paragraph 3, that they participate of their own right, which means, in other words, they are not a tool of any of the parties, a tool as in a piece of evidence. Victims participate because they have an own interest as an individual that has suffered harm from the crimes that are subject to the relevant proceedings. And they participate, therefore, in their own right. They submit their own views and concerns to the judges. And that is, if you want, why victims have their own voice in these proceedings that is not necessarily geared towards providing evidence, but it is in order to provide context to the judges, for the judges and the world to understand the extent of the suffering, not just at the commission of the crime, but also the effects of such commission. Think of the most horrid crimes that can be committed, such as sexual violence. What does that do to victims, not just at the commission of the crime, but what does that do to the victims for the rest of their lives, during which they will have to live the memories of what they have gone through? Now, the victim's participation in the proceedings is exactly the vehicle to bring the views and concerns of these and other victims to the fore, to the judges, and as I said, to the public, because our proceedings are public. Now, I just said that they're not part of the case file. They're not part of evidence. And I think this is very important also in light of what Madam Hofmanska mentioned earlier on, in terms of also where the Sunflowers project is aiming. Victims, if you want, have two potential roles to play in ICC proceedings. One of them is what I just explained to you, the role of victims. But another role, in particular, for those victims that actually have seen crimes, have seen relevant facts, or are in possession of relevant information that goes to the facts of potential charges of the office of the prosecutor. Now, what they may hold is evidence. What they may be is a witness. We would call this, for instance, a crime-based witness, a witness that can testify to the crimes as they were committed on the ground. So they are victims on the one hand, because they were victimized directly, but they also saw or lived events that are subject to the evidence that is submitted in court. For these victims, or for these individuals, there are thereby two alleyways to pursue. And one alleyway is to say, I want to become a victim in ICC proceedings. That's my business. But they can also, in addition or only, contact the office of the prosecutor because they want to impart relevant information on that office. Now, for that, there is a specific provision on the ICC website. There's a link where relevant evidence or relevant information can be submitted to the office of the prosecutor. And I'm pretty sure that Matthew Gillett has a number of other more specific pieces of information as to how the interaction between those that hold information or want to help the office of the prosecutor can engage with that office. I just wanted to make sure that it is understood that that is one thing that victims can do. And that is not what I am here for. That is not what I am talking about to you. I'm talking to you about the other angle, and that is the one where victims participate of their own rights in proceedings where they are not part of the evidence. Why am I telling you all this? Because it is very important to understand that the information that we would be collecting from victims, be that immediately directly or be that also through intermediaries, through potentially some of you who are part of this meeting today, the information that we collect is very specific because it asks the victim, what harm did you suffer? When did you suffer it? Who do you think was responsible for that? Yet all the information that we are taking in does not go to any of the parties in the proceedings. It is information that we only and solely collect in order to see whether victims actually are victims of crimes that are relevant to the specific case on record, or in the situation as in Ukraine, whether they fit into the confines of the situation. Now that brings me to another point that I think we have to be clear on, and that is the question of timing. At the ICC, we do have, if you want, two major stages that a situation goes through. A situation, first of all, needs to be defined. What is it? A situation is for us one complex where the office of the prosecutor carries out relevant investigations with a view to potentially opening one or more cases against one or more potential accused. So you have, for instance, if you look at the website of the ICC, a long list of different situations across the world. And per situation, you may have one or more cases ongoing. Right now in the Central African Republic, we have 3 cases ongoing. In Sudan, we have 1 case ongoing. And in other situations, similarly. In Ukraine, the current state is one of investigation. So the Ukraine situation looks at all crimes being committed on Ukrainian territory since late 2013. That is the jurisdiction of the Office of the Prosecutor. And within that, he is now looking at the crimes that have been committed and the potential actors that may be the most responsible for these crimes in order to then build relevant cases. And then there is the second. So basically you have this stage of the investigation. And then as a second stage, you have where a case is being brought to a chamber where proceedings against an individual, an identified individual, commence. And this is important for the participation of victims. Victims' rights in terms of how they engage in proceedings. What I mentioned to you, Rule 91 of the Rules of Procedure, makes reference to a case. That means, in other words, where the prosecutor has put on paper relevant charges against an identified individual, and these charges are brought before the pretrial chamber and proceedings commence against that individual. We, as the victim participation and reparations section, look at all the applications that we have received, and we test and we assess every application whether the crime, the harm indicated by the victim, fits in the charges of the prosecutor in that relevant case. And I'm saying that because it shows you how you could have a situation where many thousands of victims have been subjected to potential crimes under the jurisdiction of the ICC, but where then cases only take a very small picture of that and deal with a small picture of that, which means that possibly a large array of victims remains, for the purpose of that case, outside these proceedings. An example would be the Sudan situation, which is ongoing since the early 2000s, since 2003. And the one case that is currently before the chamber deals with crimes only committed in 2003 and 2004, but doesn't deal with any crime that has happened since then until the present day. Yet, as you can imagine, the victim communities in Sudan are huge, and many of them have been victimized by violence that happened after the events that are subject to the current case proceedings. The same thing can be said for the Uganda situation and a case that only takes in a fraction of the violence that has happened in the situation. Now that brings me to Ukraine. Currently, we are in a situation, we are at the investigation stage. You have multiple areas where crimes may have been committed, may be committed on a large scale. You have potentially many thousands of victims that are affected by these crimes. Yet we do not have cases yet, which means, in other words, what can victims do right now at the current situation stage? And this is where I'm getting a little bit to the details of how we operate as a section and how we operate also in a situation versus a case. Whereas in case proceedings, where we have an identified individual, we very actively go out in the field and speak to relevant victim communities that are clearly affected by the charges mentioned by the charges of the prosecutor, in order to gauge their information and explain to them how victim participation in those case-related proceedings works. In a situation, we are less active. Less active means that we try to inform victim communities of their potential rights of participation in future potential cases. And we try to inform them of how they can position themselves to the ICC at this early stage. But we also, importantly, inform victims of the fact that there may indeed not be a case that deals specifically with the harm that these victims have suffered. Cases may deal with only other crimes. There is therefore a margin of potential frustration amongst victims. And we're trying to bring this message across, not just to victims themselves, but in particular to those that stand between us and these victim communities, so-called potential intermediaries. Those of you that are in contact with huge communities of victimized people. Because it is very important for everybody to understand that the engagement as a victim with the ICC may be frustrated if the ICC doesn't bring the amount of cases out of a situation, out of an investigation that victims would like to see. As many of you know, the way how we as a section interact with victims in order to get their information is through so-called application forms. You find these application forms on the website. If you just type in ICC Ukraine, you get to the Ukraine page, and there is a little bar which says information for victims. If you click on that bar, you will find application forms in English, Ukrainian, and Russian that are application forms that you can download and fill in today. And if victims decide to fill in such a form and send it to the ICC, we would be receiving it today. We would not be sending it back. But what we do is we try to engage with these individuals or the groups that would want to submit relevant forms in order to provide the information, in order to make them understand that we are very early in the proceedings. We're very early in the investigation. And therefore, victims need to understand that with the filling in of an application form, there is no guarantee that there's going to be a case before the ICC referring to these particular crimes. So what I'm talking to you about is expectation management. We've heard Madame Hofmanska say something about re-traumatization of victims, of trying to talk to victims and hear their story without re-traumatizing them. Now, again, there's the angle of trying to figure out whether somebody has relevant information to build a case for the office of the prosecutor, in which case it's very important to talk to that person rather sooner than later, before memory fades and certain details are no longer perfectly in that person's memory. At the same time, obviously, I also see a potential impact on a victim that is being asked at several different occasions to tell their story again and again. And every time that they tell the story, they live through that story. And if you look at the horrible violence that we see today in Ukraine and around the world in all different conflicts, I think, can only imagine how taxing this is on individuals. This is why we have to be cautious in approaching victims and trying to solicit their information at early stages. Now, let me just tell you something on the technical scale. If and when we receive victim applications, what do we do with them? We as registry, we take these applications in, we assess them. We assess them against the crimes that these forms allege and whether these crimes fit within the margin of crimes under the Rome Statute that have been potentially committed in the Ukraine situation, temporal confines as well as the material confines. And we file them confidentially so that nobody has access to them. What we do not do is file these forms automatically to the chamber at this stage. We would only do that if and when a case opens, and we then reassess everything that we have received and we see which forms would fit into the case that has just been opened. And this is very important to know that whoever comes forward and submits a form to the registry today will receive a registration number, a confirmation of receipt, but the form will not automatically go into a judicial process. And I'm saying that because at different courts, European Court for Human Rights, the process may be different. And again, this is something important for victims to understand, to know. What is the scope of victims to participate at the situation stage? What could be the interest of victims to come forward now? Now, the Rome Statute is silent when it comes to the question of what victims can specifically do during an investigation. The Office of the Prosecutor is actually quite clear in that it says whoever has information that may be pertinent to the facts of potential crimes committed can and should feel invited to come forward to the Office of the Prosecutor. But again, that is not a victim-specific right. That is actually their intention to gather evidence. We do know that victims have a specific right to actually bring their views and concerns into the proceedings at specific junctures that may or may not happen. And one possibility, for instance, is a challenge to the admissibility of a case or a challenge to the jurisdiction of the ICC, where the statute prescribes that if such a challenge is being launched, victims should be able to provide their views to the specific chamber dealing with such a challenge. But absent such a challenge, there may actually not be any immediate participatory right of victims of a victim to bring its views and concerns to the judges. So I think this is very important also to keep in mind. The participation at the situation stage is fairly limited, and actually the music starts playing the moment that a case commences, because this is where victims' participatory rights flourish and are also specifically outlined in the regulatory framework of the ICC. This is where victim participation is the most important. And it makes sense if one considers that the interest of victims is to argue their specific suffering in front of judges and in front of potentially those that may have been responsible for their suffering. I just want to make clear what victims can expect at the current stage. This is why I'm dwelling on this for so long, because we have to consider that the investigation may continue for many months in this situation, and that cases may come only after a time. And usually my or our advice to victims is be in touch with us, stay in touch with us. And when these case-related activities commence, this is the moment where we have to sit together and become active in terms of us collecting information from victims. That said, I also am cognizant of the specifics of the Ukraine situation, where many victims fear for their lives, fear for their security, and may have no idea what is going to be their situation tomorrow. They may want to submit their claim to be a victim of violence in the situation today, because they don't know whether they will have the possibility to do so tomorrow. And we're urgently aware of that. And this is why I'm saying we will never turn away from receiving any information from victims, in particular in light of this fact. At the same time, again, we would be adamant about explaining what victims can expect at this stage, in order for there not to be false expectations as to what the ICC will be able to perform, what it will be able to do. And this then relates back to, as I said earlier on, the Office of the Prosecutor potentially only bringing a small number of cases. That doesn't comprise the entire criminality of a given situation. And this is where we all that are involved in these proceedings have a role to play in, on the one hand, trying to pave the way for justice, but on the other hand, also be realistic and explain to everybody involved to be realistic about what can be achieved. And as a very, very final point, I want to quickly say something about the potential security issues that victims may be facing. The court does have a section that caters for the security and safety of witnesses, and it is called Victims and Witness section. So it actually seems to also hint at victims being able to receive certain protection from that section. However, the protection that is yielded to victims is protection in a case scenario where these victims have any specific dealings with the court, be that as a witness or be that as any other contact person that is in touch with the court and at risk on account of being in touch with the court. This does not relate to the victims generally participating in the proceedings. What does this mean? When you interact with us, when you choose to interact with the court, what we can do is we can advise you on the securest vehicle to do so. That is using secure channels of communication. We can guarantee that the information once submitted to us is kept safe and confidential and will not leak. But we cannot provide active protection of those in need of protection in the field or else how. That is an important factor because we hear often that victims and victim representatives say, we're under immediate threat. What can you do, dear ICC? We have submitted an application form to be victims. The unfortunate answer here is that the protection is one that refers to the information that you're submitting and advise on secure channels. And this is unfortunately all we can do at this stage.